here, myself, I'm Martin Nocton, I'm the judge, and to my left here we have Yashin and Eve, and they will challenge some of the arguments and will also assist in making the final decisions, right? And then we have the team for Johnny Cash, where? Here. And would you like to introduce yourself?
My name is Jana Litinska. I represent Johnny Cash in this case.
Yeah, I'm Sanjay Jain, and I represent Johnny Cash in this case.
Ibtisam Ilkaya, I represent Johnny Cash as well.
Okay. And we also have the Westeros government.
I'm Eric Matthews, representing the government of Westeros.
I'm also Calgary, representing the government of Westeros.
I'm Manuel Bada, representing the Westeros government.
Okay, thank you very much. And we also have some other interested parties here as well, which we may or may not get to during the course of this morning. Just for yourself, we have 15-minute open arguments, first of all from Johnny Cash, and then from the government to respond to that. And then after that, we have 10 minutes each again, and then finally, one final minute. Now, at any stage, there will be some interruptions and cross-questioning coming from here and also across from each other. I want to say to you, though, that if that becomes too much, and if there are too much interferences in terms of time, etc., that we will just simply reduce the amount of interruptions. And if there is interruptions just for the sake of interruption, we might deduct time from you. All right, so from your 10 or 15 minute time, or even your 1 minute. We're here, it's a very serious situation, not alone for James Brown, whose life and well-being we're considering this morning, but also remember that whatever we decide here will also be some precedents maybe for other people in similar situation. So it's quite serious. Okay, thank you very much. And now I'm going to hand over to Johnny Cash.
Just one question, Judge. Could you please announce protocol? First of all, how we should refer to the court, and secondly, whether we should stand up. Protocol for this hearing.
Did you not go to college? No. Anyway.
Should we refer to you as your honor?
Of course.
Our party allege that in accordance with Article 1.1 of the optional protocol to the CRPD Convention, there were violations, and Mr. James Brown is a victim of violations by the state of the provisions of Article 12 and 19 of the CRPD. We allege that the government of Westeros has violated the provisions of the conventions on the following grounds. First of all, we claim that James Brown, who is the son of the claimant, was never given a real opportunity to choose where and with whom he should live, which, in our opinion, violates Article 19A of the Convention. Mr. Brown was never asked whether he wants to move to become a resident of so-called independent residents. This decision was made for him and without his actual participation. His mother, Janis Joplin, has signed the agreement, and we ask ourselves, what a real choice did he make? What is his real choice? Did he have an opportunity to move to the independent living, or move to independent living, or probably to move to the independent living, nobody tried to explain to Mr. James Brown that he does have a choice to move to, for example, his father's home, or investigate other accessible options for him. The fact that his mother is not able to cope with his behavior and is not able to live with him now doesn't really mean that his only accessible option is that the one which was provided to him. We also accept that Mr. Brown has signed a representative agreement. We understand that the role of his mother now is called representative. But due to her behavior, when the representative has never asked her son to whether he wants to move or not wants to move, what is his interest, what is his choice, we do not see a real difference between this word representative and the old system of guardianship. What is the difference if we basically doing absolutely the same things here? So CRPD, in our opinion, should not be about naming something more in a nice way. It should be about paradigm shift. It should be about some real choice of the person with disabilities. But Mr. Brown didn't have this choice because his, I would say, guardian made this choice for him. We also want to argue that there is a question about validity of this representative agreement, since we don't see that it was fully and truly informed choice of Mr. Brown. We have no information that Mr. Brown was ever acquainted with the fact that he could, for example, sign this representative agreement for both of his parents, not only for his mother. So whether the choice of Mr. Brown was really independent, we think that was not the case in this situation. This was not an independent choice. Therefore, we believe that there were a violation of the state to protect of right of the Mr. James Brown in such a case, to protect and integrate, so to speak, mechanism of control, whether his choice can be independent in such a case. Secondly, we allege violations of the Article 19b and 19c and Article 3 of the CRPD conventions. We believe that placing James Brown into so-called independent living constitutes violation of the CRPD because of the following reasons. First of all, we have to consider what is that, the independent living here. Is it really independent, or is that just a thing that we call nicely? Mr. Brown now lives in a place where he can basically communicate only with people with disabilities and the staff. Let's face it. So is that independent living, or is that a segregation? Is it so much different from the institution? If we change the title, it doesn't really mean that it is independent living. Okay, why somebody believes that it may be independent living? Because Mr. James Brown has signed a representative agreement. He have never even signed the documents concerning placing him. He might be not aware about this fact. And let's also see what he is actually doing in this so-called independent living, what kind of activities he's engaged into. Well, he can go with some people to the swimming pool, but if he really wants to go to the swimming pool, is somebody asking him whether he wants to do this or no? Maybe he wants to run with his father, and that is the fact that we know about him, not the fact that he wants to go to the swimming pool. He is also in some so-called protective measures, which is tying him to the wheelchair. Is it protective measures that are allowed in modern democratic societies? This country, Westeros, is a member of the Council of Europe. I don't think that this is the practice that really necessary and that really constitutes protective measures. What is he doing there? Is he engaged in some kind of activities that are useful in his life? We don't think so. He doesn't have any obligation. So let's face it, it's institutionalization. He's living in the institution. It's not an independent living. And that violates the principles of the convention. and that violates...
Counsel, in what way would I understand that your client is asking for placement of Mr. Brown with his father. How would that be more independent, continuing to live with your parents as an adult, than being in an adult home with other people?
I understand your question, thank you, Judge. First of all, we have to say that every person is entitled to live on the equal basis with others. Many people believe that, for example, living with parents is a good option for them. We are not saying that it is the only option, but sometimes it's good. We also believe that living with father, in this case, is good for Mr. James Brown because, first of all, he is able to engage in some real-life situation. He is able to communicate with other members of the society. He is able to have an obligation. He doesn't have any kind of obligation like any adult person or any even child in this facility where he lives. So this is important factors about inclusion but not exclusion. It's segregation, it's ghetto where he lives now. Have I answered your question?
You have, thank you very much.
And thirdly, we allege violation of the Article 12.3 of the CRPD. We have to cite that according to the paragraph 3.3, page 7 of the case citation, the court of the Westeros has said, citation, living in the independent service living was right for him, was right for Mr. James Brown. We believe that CRPD is not about best interest, and that is not the question that the judges should have answered with this case. They should have answered how we can, as a country, Westeros, support our Mr. James Brown. This question was never asked. This question was posed differently. What is the best interest of James Brown without his will, without him even knowing about this?
So, excuse me again. So you see a conflict between best interest and full independence. That would indicate to me that you're asking a government to give up any protective role that it has for Mr. Brown and leave him to fend for himself. How do you draw a line that protects at least some best interests and doesn't leave independence to mean you're on your own and living on the street?
Your Honor, first of all, I have to say that in accordance with CRPD and also in accordance with the law of the state, which was adopted under the CRPD, we see that some decisions, something like direct harm to our own life, may be more, so to speak, protected. However, our main point here is that support should be provided before assessment of the interest. Our main point here is that this support was never provided to Mr. James Brown. So we do not see, so to speak, the fact that he's not able to communicate the same language as most of the people in Westeros are able to, as he doesn't have a choice or doesn't have a voice. Maybe he's not able to communicate in such a way. So we don't see it as a fact, we see it as a process. And we want the government to protect this interest, to adopt supportive measures, positive measures.
For his communication or
for communication and for his support in making the decisions concerning where he should live.
And what would those measures be? I see in neither of the parties' briefs nor the mother's brief what those measures would be. Each parent indicates that they just know what he thinks.
Your Honor, this is a very complicated question, and I don't want to, so to speak, make some assumption without actually seeing the person. We are not speaking about facts. We are speaking about the person. We are not speaking about disorder itself or something which is very far from the reality. So I think this demands, for example, real support of let's say, professionals and family members concerning what can be these supportive measures. I don't want to say this will help to this person because I really don't know what is this now. We don't see Mr. James Brown, and I think we should see and hear him.
I agree. Where is he?
That is the question, Your Honor. That is the question. That is why we are here. That is why we are here. So, may I continue?
Yes, of course.
So, as we said, we believe that supportive measures should be provided by the government. And as I said already, we believe that even if Mr. James Brown is not able to communicate the same way as most of the people in Westeros can, it doesn't really mean that his voice and his choice shouldn't be taken into account. We should ask him first before deciding about the best interest for him. Therefore, we claim that the government of Westeros has failed to adopt all appropriate legislative, administrative, and other measures for the implementation of the rights recognized in the present convention. We also believe that due to these violations, we have to see the convention in complex, so to speak. If he is placed now in this so-called independent living or institution, his other rights, such as right to family life, which is in accordance with Article 23.3 of the Convention, right to education, and other rights such as privacy and integrity might be also infringed. So therefore, the failure to provide such measures cannot be tolerated in modern democratic society that has signed CRPD. Thank you very much.
Thank you. Westeros.
Good morning,
Oh, did they have more?
and I would like to thank the court for their work in protecting and promoting the rights of people with disabilities around the world. I would like to stress that the government of Westeros is also very committed to promoting the full integration of people with disabilities into society, and I believe that this is clearly evidenced by the fact that the Legal Capacity and Independent Living Act Westeros drafted was enacted in 2007, 1 year in fact before the CRPD entered into force. So the government of Westeros has been at the lead of the pack, front of the pack, in making sure that all people with disabilities have equal opportunity. My argument for the government of Westeros is a simple one. The entire opening statement of the complaint was based on question of fact about the case, which all local courts and regional remedies have already upheld the validity of the representative statement and case and determined that there is no undue influence on the case of the mother. So our argument is based on the compliance of our law with Articles 12 and 19 of the CRPD, not, in fact, on the application of the law in this current case. I would like to respond to the opening statement of the complainant by pointing out that they did insert facts that were not included in the brief submitted to the court, including the fact that James Brown did not have the opportunity to be asked whether he would like to be represented by his father or others. The law, in fact, gives the opportunity for the person under a representation agreement to choose one or several representatives in several areas of life. The James Brown, as local courts have upheld, has chosen his mother to represent him solely. It's also obvious that the
I
father...
would like to object, although the law gives opportunity, whether the opportunity was really given, because there is a duty under Section 3, I think, of the law to provide assistance of an independent lawyer to the person with disability, whether that assistance was provided. What about the compliance of the duties? Law is there, but whether it is complied.
May I respond?
Yes.
Article 2.1 of the Law of Westeros mandates the creation of networks of support throughout the community, and one of these supports is a mechanism for people to establish a representation agreement with one or more trusted persons to assist in explaining the information relevant to a decision. And to your specific point, the The article also states, for those who do not have a trusted individual to fill this role, to assist them in finding a representative, Article 2.4 of the law states that local authorities will supply independent advocates to help persons with disabilities develop supportive networks. So this specific situation is very clearly noted in the law.
What were the networks that were supplied in this instance?
In this instance, the law mandates that the local communities develop supports and networks throughout different services in the community that people would need. But specifically, it also mandates the creation of social support networks to make sure that people develop trusted individuals with whom they can get to know better and maybe eventually develop and choose of their own will to form a representation agreement with. So there is a positive obligation on the government to make sure that everybody has a supportive network. I'd like to move on to how I'd like to structure my main argument, which is compliance of the Act with the CRPD. So my argument is very simple. I'm going to go through the CRPD Articles 12 and 19 and state how line by line it is compliant fully with what the CRPD intends. Articles 1 and 2 of Article 12, Article 12, 1 and 2, states that states parties reaffirm that persons with disabilities have the right to recognition everywhere as persons before the law, and that they shall recognize persons with disabilities as enjoying legal capacity on an equal basis with others. Indeed, we have recognized and reaffirmed that right. Article 1.1 of the Legal Capacity Act states unequivocally, persons with disabilities in Westeros enjoy legal capacity in all aspects of life and have the right to equal participation everywhere as persons under the law. 12.3 of the CRPD states parties shall take appropriate measures to provide access by persons with disabilities to the supports they need in exercising their rights. I'd like to point out on this note that guardianship no longer exists in Westeros. It has been replaced completely with a supported decision-making system. Article 2 of the Westeros law outlines the measures that the government has taken to ensure all persons who need supports receive them in the community. Article 2.1 of the law mandates, as I just said, the creation of networks of supports and making sure that people who do not have them are surrounded with people to develop those trusted social connections. Article 12.4 of the CRPD states parties shall ensure that all measures that relate to the exercise of legal capacity shall provide for appropriate and effective safeguards to prevent abuse. There are plenty of safeguards, even sufficient and maybe exceeding the requirements of the CRPD in the Westeros law. The CRPD states that such safeguards shall include measures to make sure that the rights and will and preferences of the person are included. Article 1.3 of the Westeros law expressly recognizes this safeguard, declaring a right under the law to access all arrangements and supports for exercising legal capacity in accordance with will and preferences, and further elaborates on this right in Article 3.1, mandating that all persons filling the role of representative must help a person understand all information relevant to a decision, including information about consequences, but also specifies the right of the person to establish with their representative legally binding advance directives in the case for who, when, and how decisions about their health care or personal care will take place in the event of complete incapacitation, such as a medical coma. Safeguards also include absence of conflicts of interest and undue influence by Article 2.5 of the Westeros law, which mandates that all local authorities must bring to the attention of the courts any situations which raise concern for a conflict of interest, undue influence, exploitation, or disregard for a person's will or preference. And Article 4.1 of the law expressly forbids healthcare providers or employers of such services to be representatives, actively foreseeing a possible conflict of interest.
Can I ask a follow-up question regarding the conflict of interest? I think this is fairly important in this case. Article 4 of the Westeros law indicates that a person cannot be a representative if he or she provides personal care or health services for financial compensation. However, the parent here did provide personal care and health services as a parent, not for financial compensation. Why is that not also a conflict of interest? Given, for example, and I'm not saying that this is necessarily the case here, but a parent who wants to avoid the burden and the duties of providing those services, whether they're compensated or not, may be an undue influence and may have a conflict of interest in determining where the child should go.
Well, I think that's a very good point. And I think that speaks to the inability for any law to expressly foresee specific instances. So in the case that instances like that may come up, I do think it's very important that Article 6.3 of the Westeros law allows for the cancellation of representation agreement by the courts by any third party upon application of any third party where there is a concern of a conflict of interest. So anybody, including the complainant, as we see in this case, or a local authority who is also mandated under the law to report conflicts of interest, is required to report that conflict of interest to the court, and that representation agreement can be canceled at any time. I also think it's very important to restate that all persons under representation agreements maintain their full legal capacity at all times, and it is expressly described in the law that any person under a representation agreement can replace or dismantle it at any time with their signature or with the approval the approval they give a third party.
But in the case of James Brown, what sort of support to assess his capacity as being given other than the representation agreement? Despite all the articles included in your law, the legal capacity law, what other option would give James Brown to assess his capacity and to decide other than the representation agreement?
I'm sorry, can you ask me the question one more time?
Yeah, my question, what kind of other alternative support given to James Brown to decide on his residence, place of residence?
I'm glad you asked that. Article 7 of the Westeros law provides for supports for community integration and for support, and it outlines several areas in which the government is mandated to give support, including access to services in the community, access to education and employment and other things they would need to live independently. I do think it's important to note that in this particular case, the mother chose to put, the mother in consultation with James Brown chose for James Brown to live in the tenancy because of the existence of the picture exchange communication system to learn how to communicate. It is
Objection.
We've asked we don't actually have objection opportunities here, but you can respond.
In accordance with the rules for this case, we are not allowed to make references to the information that was not given in the case. So please.
That would be a problem for both parties at this point.
I
Objection
Well,
overruled.
I would just like to point out that the information was given in the case by the witness statement of the mother, who states in her statement that the tenancy agreement is teaching him how to use a picture exchange communication
Yes,
system.
but it doesn't mean that the tenancy.
The objection
agreement
is
was-
overruled, and I will ask counsel to continue.
Thank you. I would like to move on to Article 19 in the interest of time. However, I would like to point out that all of the safeguards under Article 12 are also fulfilled expressly under the Westeros law. Under Article 19, in accordance with Article 19 of the CRPD, Article 7 of the Westeros law provides that persons with disabilities shall enjoy a right to live on their own, in their own home, with the support they need to live independently on an equal basis with others. Article 19 of the CRPD, first of all, thank you, stresses the ability for a person to choose their residence and with whom they will live on an equal basis with others. Article 7 of the Westeros Law fulfills this by allowing for a payment of funds to fulfill the right to independent living, which can be used to live in a home of their own choosing. And I do think it's very important to note that these funds follow the person and not a residential service. Therefore,
I have the statement, I believe, of Ms. Joplin has raised the issue that his budget is insufficient to provide him the level of independent activities that she appears to want him to have as his representative, and that his father appears to want him to have. So how is this very apparently limited budget being adequate to support what the law claims should be provided in terms of independent activity?
that's a very good point. And
I thought so.
my answer to that question is very simple. In this particular case, what we are hearing is the desire for the complainant to provide full support in the community in a remote village away from the city. We understand and accept that critique and strive to fulfill the possibility to provide all of those services in remote communities in the future. However, a country has to start with its implementation somehow, and with limited resources, we have decided to focus, according to international standards, on providing services and supports in the cities and near the cities to make sure that people have the fullest opportunities for integration.
But dollars, objection.
Oh, no objections. Would you like to make a comment?
Sorry, dollars considerations cannot override the mandate of Article 90.
Actually, I think there may be budgetary limitations that are permitted, but it's not clear how you're making those budgetary determinations under this statute.
Okay, the budgetary decisions under the statute are decided in regards to, in regards to maximizing independent living with the available resources available. And we have prioritized community living in the city with the idea of progressive realization will eventually allow us to expand those services to remote villages. I would like to continue on to say that Article 19 of the CRPD also mandates access to a range of in-home and other community support services. And as elaborated very clearly in Article 7.1 of the Westeros Law, these funds, which follow the person, are provided to access supports which are specifically elaborated in the law, including allowing them to live in their own home, gain employment, enjoy family life, and develop and sustain relationships, access education, access the community, and participate in civic and political life. By elaborating these specific rights in the law, we have not merely just put a label on independent living and given blank funds. We have said and given an express right to people with disabilities to receive funds to fulfill these basic human rights. And finally, Article 19 of the CRPD stresses that services and facilities for the general population are available on an equal basis to others and are responsive to their needs. And I'd just like to point out that Westeros law fulfills this requirement through Article 2.1, which mandates the creation of community networks and supports, and further, once again, guarantees the right to access these services under Article 7. I've taken the time to go line by line through Articles 12 and 19 to show that the government of Westeros is taking care in drafting the Legal Capacity and Independent Living Act to be fully compliant with every aspect of these two articles of the CRPD. The country of Westeros continually strives to increase the community integration and independence of our citizens with disabilities, and we look forward to working with the committee to bring the entire convention fully to life in Westeros. Thank you.
Thank you.
Just in a little while, we may also call on the NGO, Life Choices and Voice, to talk to us for about 10 minutes. We may wait until after the rebuttals for this, and just to help us in terms of influences. So maybe first I go back to Johnny, to the claimants, and ask for rebuffal. Mhm. This is for 10 minutes, and we can allow objections. Right,
We've
okay.
gotten mixed signals on
Huh?
We've gotten mixed signals on
We
objections.
have, yeah. It got lost somewhere in the Atlantic, transatlantics. But again, we keep it tight. And occasionally as well, if there's anybody who feels very, very strongly in the court that are in the city, that they can also object and jump up. Okay? Once or twice at
In the
least.
city.
Huh?
Anyone in the city.
In the city, yeah. Okay, thank you. You're 10 minutes now.
Well, when I hear the arguments of my learned friend, I feel that he has taken us to the jungle of contradictions. He is trying to miss wood for the tree. It is one thing to say that approximating the legal regime to the provisions of CRPD is compliance, but quite another to apply it to the actual case. And I don't think that he would do a good job to hide behind a judgment when the complaint is made by the father of the kid, father of the young lad before this coming.
May I make an objection? My objection is to the relevance of his argument to the case. This session before the court is about the compliance of the law with the CRPD, not with the application to the current case.
Overruled on this occasion. Mm-hmm.
Thanks, Your Honor. Now I would like to turn to his arguments one by one, rebuttal. First of all, if you look at Article 19 of UNCRPD, there are three important issues, three important values underlying Article 19. That is choice, support and inclusion. And we have to see how on all these aspects there is application of law. What about choice? Whether the representative agreement was the only choice, whether it was the last choice or whether it was the first choice. There is no argument. Why he was asked to go for representative argument, whether his legal capacity was assessed. There is no argument. Then about support. Now his own law talks about, their own law talks about duty. There is a provision in the law for providing support, and the provision unfortunately is couched in a duty language, whereas we are expected to promote rights discourse, which should have been the other way around. But anyway, even if we assume for the sake of argument that the provision complies with the UNCRPD, in what manner they have fulfilled their duty in assessing the capacity and providing adequate opportunities to the young lad and asking whether he wants to go for representative agreement or whether he has other supports. I see no argument being made. It was merely a recital of provisions of the law. Okay, law looks fine, but what about its application? Now, going back to the Article 12. Now, at the substratum of Article 12 is very important right, which is known as right to make decision. Now, I would like to invite the attention of the committee. I would urge that right to legal capacity is not a single right, it's a compendium of rights. And one of the most important rights under Article 12 is right to make decision. So in what way the state helped, the state provided support to the young lad to exercise this important right? I see no argument made. I only see recital of the provisions of the law. Then going back to the fund argument, that it was stressed that fund follows the person. If fund follows the person, then why attempts are not made? Why opportunities are not explored to see that funds are provided in the home of the father of the young lad? Why it was assumed that living in a residence, which is of course euphemism for an institution, why no effort was made? And what about surveillance? What about the surveillance? The lad was on constant surveillance for 24 hours, 24/7 he was on surveillance. What about the so-called treatment which he was being administered?
Objection.
Yeah.
There is no reference in the statement of facts to 24-hour surveillance.
Yeah, it is there in the fact sheet that he was subject to the constant visit of the staff. I'm sorry, I don't have fact sheet, but it's like that.
Okay, I do not believe the term 24-hour surveillance is used.
I object to the term surveillance.
Okay,
Another thing is about. Can I continue?
you can without surveillance.
Yeah. Okay, it's not surveillance, maybe under watch. But even can you keep him under watch? And will it not violate Article 15 of UNCRPD? It is not a inhuman, cruel and degrading treatment. And what about the so-called treatment?
Objection. The idea that someone be under watch to make sure that they receive all the medical supports that they need does not violate Article 15 inherently. I think you would have to provide a lot more facts to attempt to even begin to make that claim.
That doesn't appear to be related to relevance, the adequacy of the legal basis, or any prejudice. The court is capable of making those kinds of weighing and analysis.
Continue.
Then the last point is about the principle of human dignity, which is at the core of UNCRPD. Now I see everybody trying to decide. The mother trying to say that it is in his best interest to stay in a flat. Then the state trying to say that okay, when he stays in the flat, he's likely to grow better. He's likely to improve. But I think it's all euphemism for best interest. And again, no effort is made from the other side to counter the argument of best interest. So I would conclude by saying that all in all, although the law looks like a compliant legislation, it's a euphemism. We are simply replicating the provisions of CRPD into law, but when it comes to application, probably we are missing the point.
First, they argue that James Brown was not given the opportunity to choose for himself, to make a decision for himself as to his living arrangements, but under Westeros law, we have to agree that all the rules about representation agreements, which James Brown has entered with his mother, all the rules have been respected. And as he is unable to communicate, choices have been made, have not been made for him, but he has been supported into making those choices. So as far as Westeros law is going, we think he had a choice. He had the choice that the person that he chose to represent him and to support him, that person made the choice that he thought would represent best his will and preference. So, in our opinion, James Brown was given a choice. They said that the representative agreement, as applied in Westeros, amounts to guardianship. And that it doesn't allow James Brown to communicate. Well, with this representative agreement, living in the independent living, then it's written in the briefs that James Brown is currently learning to communicate more efficiently than it was before when he was living with his father. Then they argued that the representation agreement was not valid because it was not an informed choice. And in that, they ran afoul from Article 1, Section 4 of Westeros, the Westeros Legal Capacity and Independent Living Act. Because, as it says, legal capacity of a person with disability shall not be questioned or denied, irrespective of the degree and extent of support, by reason of accessing support to exercise legal capacity. So, we believe that argument doesn't stand. They argue that there is no mechanism of control for the system that is applied in Westeros for independent living and legal capacity. But it's clearly stated that any third party can go to a court of law and question and challenge anything that is happening under this Legal Capacity and Independent Living Act. And we think that once the challenge has been made, we believe that the legal system in Westeros is fair and independent, as all legal systems are always.
Excuse me. Seen a lot of legal systems. But it seems to me you're making a sort of circular argument here in that saying because someone can challenge the determinations that have been made here, and because someone has, they must lose because they had the opportunity to challenge. They actually have the opportunity to be heard and to have their hearing considered. The fact that they have an opportunity merely to challenge is not sufficient to say that the law must be upheld, because we have to listen to the challenge, we have to consider the challenge and make decisions on the challenge.
But there is an arena where these challenges can be brought.
And they have, and this is one of them.
As to Article 19 of the Convention, they argued that this independent living amounted to segregation into institutionalization. But we argue that that's life in society today on equal basis with everyone, because a lot of us are not living alone in our own home, but have roommates. Mr. James Brown has roommates. I don't think that's a shame. That support is not support measures were not provided, but as my esteemed colleague argued, there is a budget with which Mr. James Brown can purchase support as far as the budget allows it, but like everyone, Mr. James Brown has limitation of budgets. I would love to live in a duplex in Park Avenue, but I can't. And also, they have, that will be my last point, they have criticized the best interest approach. And I just wanted to point out that Mr. Cash, who is Mr. Brown's father, himself in Section 7 of his statement, argued that persons with disabilities should be able to live with their families if that is best for them. And if that is not a best interest approach, I don't know what is. Thank you.
Right. And if there are no questions from colleagues here
Yeah.
at this stage?
So could you explain, could you make it clear which provisions of Capacity and Independent Living Act make so James Brown's choice at the beginning of legal representative agreement so guaranteed? Which article provides the protection or guarantee to make his choice freely or sufficiently?
2.4, but also
in section 2, paragraph 4, it says that local authorities shall supply independent advocates to support persons who presently have no appropriate networks of support for the exercise of their legal capacity. That would be if Mr. James Brown has no support at all, but he has. But then there is Article 6.
Yeah, so especially could you explain your explanation, so interpretation about Article 6, 1b. So it seems to be automatically validate the representative agreement. So for the case of James Brown.
It is up to a judge to assess the characterization, to assess that the relation is, open quote, characterized by trust. And so on that, we have to trust the justice system.
Who decide this? The court will assess this criteria afterwards. So under the Article 6.2b, so court can make it invalidate. But at the beginning, so representative agreement start validatory, so almost automatically without any court intervention or some judgment.
Thank you for your question. Under 6.1a, making and dissolving a representation agreement, it specifies that the person making the agreement is able to communicate their understanding with support. Support is provided as outlined in other areas of the law. The nature of the agreement, which can be on one or several different areas, depending on what they like, and it can also be one or more persons. And their choice of representative. Should be noted that in this case, the son chose only the mother. He could have chosen both the mother and the father. And it does say, in direct answer to your question, that they signed the agreement on their own behalf, but in the presence of an independent witness. So that independent witness is a safeguard against any, perhaps undue influence or conflict of interest with the mother behind closed doors or whatnot. So that is an open process.
But for James Brown, he cannot, so in this case, he cannot communicate or understand the nature of the support or the agreement. Is it correct?
All we can say is that he cannot communicate, but as to his understanding, I don't think.
So, in my opinion, in his case, so the Article 6.1b will be applied to this case.
Yes, that's, I think that was mentioned.
So without any signature or without any, no?
The way the law is written, if you'll excuse me, it is not an either or. Both A and B must apply.
Both A and B.
Yes.
Your interpretation, okay.
Thank you.
I'm sorry, I object, but there is a clearly or in the law.
Where is that? Or
Please read carefully.
At the end of 6182, or
yes. However, the choice was up to the son with the support of people who know and understand his decisions. And I will stress that the son chose his mother, not in an either-or situation where he had to choose the mother or father, but with an independent advocate in the room. It was agreed that his desire and will and preference was to choose the mother, and only the mother, as his representative. If there was, for instance, a situation where he expressed, as outlined by the father, that he wants to live with the father, then the independent advocate would have been in the position to suggest that the true will and preference of the son in this case was to be jointly represented, but that is not the case. I will also point out that we are debating, I believe, question of fact, and that this has been reviewed by courts before. And it was confirmed in court. Thank you.
May I ask a question to the other party, where in the case he has found the line that actually a choice between mother and father, or any kind of references on opportunity to sign representative agreement for a father was mentioned. Please indicate this in the case. I really don't see it in the case. So
Can we have the page number, please?
Yes, I'm not suggesting that it is in the facts that what I'm telling you is that, and we can't know what happens in the court with the independent advocate in every room behind every door. But what I'm telling you is that the system, the way that the law is set up with safeguards, is that there is an independent advocate, not only in this case, but in everyone. So I'm suggesting strongly that he only wanted to be represented by his mother because he had every opportunity to be represented by both and had an independent advocate to stand up for him in the case.
Okay, thank you. Just there on the second row, did you want to ask a question? Mm-hmm.
Oh, no, not me.
No? No. Right, well then, we're going to move on to the NGO.
I don't see that there's an independent advocate in the room.
Yeah.
Microphone on. Now you have 10 minutes.
Good morning, Your Honours, ladies, gentlemen, Reverend Fathers, etc. Our view is, we're coming at this case, obviously, just to offer some observations, not advice, not rulings, not anything, but we have some views on both Article 12 and Article 19. First of all, the committee has not heard the perspective of James Brown at any point. It has not been heard, he's not had the opportunity to express his will and preference here, okay? Secondly, all of this is a very technical debate about technicalities of the law, about the choice of somebody, but this choice is being imposed on somebody. This man was not asked whether he wanted to make a choice. This is a squabble between his parents, or at least it appears to be a squabble between his parents, that he is being required to solve, going through all this rigmarole of choice, and is it this article, or that article, or the other article? He's not an object, he's a person about whoever people are arguing, completely with nothing to do with him. He's dragged into an argument between his mother and father, basically. He didn't initiate the decision, so he's being required to make a decision between his mother and father. And on making that decision, umpteen other life-critical decisions are going to be required to be made of him, all because his mother and father are falling out about what's best for him.
Are we allowed to object on this? Okay. Objection that he did not, you stated that he did not make the decision, I assume regarding the tenancy. I would argue that he did, because he made the decision to be represented by his mother specifically in the area of accommodation. If he disagreed with his mother on her accommodation choices, he could have chosen not to have her represent him in that area, or at any time, even now, he could choose to dismantle that agreement. So I object to the idea that he did not choose.
Can you point us to the piece of the law that indicates that there's an independent representative in the decision to choose your representative? Because I have not been able to find it here.
Okay. Yes, there are two areas in which we have interpreted the law to mean that in the application. The first area is 6.1ai. Or 6.1a1, to sign the agreement on their own behalf in the presence of an independent witness.
And that indicates that the independent witness is able to, at that point, independently assess whether the person's choice is being made by them as opposed to the representative? Because this is not indicated here.
Yes, in
It sounds more
interpretation
like a
that-
notary.
Well, in interpretation, that is precisely the role that the person plays. I would say that that intention is also backed up by, I believe, in the Westeros Article 2, where it mandates both community networks for supporting and accessing legal capacity support networks, and also the fact that if a person does not have community supports for trusted individuals, that they provide them. It would be, in my interpretation of the law, those trusted networks of supports that the government takes a positive obligation to create, who would be the independent witness in that room. The purpose of having an independent witness is to make sure that everything is true to the person's desire.
That's not always the purpose of an independent witness. An independent witness witnesses that that something has been made and signed.
Thank you, and I agree it could be more clear in the law, however, that is our interpretation of the law.
And was it applied in that way in this case? There's no record of that either.
Right, let's continue.
There isn't that much more to say. That was Article 12. We don't feel that the man has been given an opportunity. First of all, please hold the thought that all the state has just argued within the case, which is fine. We are pointing out that all of this, while it's within the case, this man is being drawn into the case. It's not a case with or about him. Well, about him, but not that he initiated in any way. There aren't sufficient supports, it seems to us, for the Representative Act to actually understand what the man does or does not wish. And finally, there are not enough safeguards to comply with 12.4. E.g., this can only be challenged if someone raises an objection. No continuous monitoring within there, no potential, or there is definitely potential for conflict of interest. And it's not like he can just change his mind in the morning. Whatever decision is going to stick for years, because even if he decides to change his mind, it's back into another process that will take time, and meanwhile his life is passing. This is true of all of these kinds of decisions. So first of all, I think we need to consider, is he really concerned?
Your Honours, if I may add some of the technicalities as to whether the Westeros law is, in our opinion, in the opinion of my voice, my choice, in accordance with the CRPD and specifically with Articles 12 and 19 of the CRPD. Now, we appreciate the efforts of the Westeros government to bring the domestic law in line with the CRPD, and I well understand what the government representative has said about their opinion, whether the wording of the law is in compliance with the CRPD. What we would like to stress the fact that the duty of the state party is, when it comes to the duty to fulfill the rights contained in the Convention, it is not just to ensure that the law looks fine, but it is implemented and applied in full compliance with the CRPD. And here is where we have some concerns with regard to the law, because when looking at the Westeros law as a whole, we, on our part, see some shortfalls in the law itself. As my colleague pointed out, there are some shortcomings when it comes to effective safeguards. Now, the government representative pointed out that there are plenty of safeguards and referred to Article 6 of the Westeros law in specific. In our view, these safeguards provided by Article 6 of the domestic law do not provide appropriate and effective safeguards. Let me illustrate that. As was discussed earlier, and as has the committee also referred to, Section 6.1b of the Westeros law offers huge potential for conflict of interest in and by itself, as actually the present case clearly shows. And the only option the complainant had in this case was to enter, because of his communication problems, to enter an agreement on the basis of 6(1)(b) of the Westeros law, which is actually not providing for that independent witness that was discussed about earlier.
Objection. With relevance to no safeguards in that fact, I would point out that even in the situation you pointed out, the person still retains full legal capacity at all times and can at any moment dismantle the representation agreement or replace it, or a third party who is concerned with a conflict of interest can appeal the case to the court. So I would argue that even in that situation, there is a vast array of safeguards still available.
Please continue.
If I may answer, thank you for that objection actually, because that brings me to my very next point. Because there's a lack of continuous monitoring provided by Section 6, meaning that there's no continuous monitoring provided by a court out of its own authority. You always have to file an application to the court, be it any third party under 6(3) of the Westeros law, or being the authorities under Section 2 of the Westeros law. The mere fact that if a person with disability needs to file an application with a court, even if he may do so at any time, may in itself constitute a procedural threshold which can be an accessibility problem and constitute a barrier in itself.
I would like to make an objection to that point as well. You pointed out that there is not a regular review. If you'll note in CRPD Article 12(4), after it talks about the necessary for a regular review as part of the safeguards, it also states that the safeguard shall be proportional to the degree to which such measures affect the person's rights and interests. And once again, I would state that there is not a need for a regular timed review body due to the fact that the person or any third party can apply at any time. To your point that the person may face barriers in accessing the system, that is why we have expressly put forward in both the independent living section and the legal capacity section of the Act the necessary supports to access all legal services. So that problem has been foreseen and is being addressed in the application of law. Thank you.
I believe this is a matter of interpretation of the law, which is then up to the committee. We would just like to point out that at no stage of the previous court proceedings nor at proceedings before that committee, the complainant actually, or Mr. James Brown has actually appeared himself and was asked or heard himself.
Objection. There's nothing in the facts that suggests that that's the case.
Okay. That's our understanding of the facts.
Anything else?
Yes.
Yeah.
Yes. One thing regarding the Section 5(2) of the Westeros Act, where it set out the criteria and decision-making by a representative. Regarding that clause of the law, we would like to stress that concerning persons with communication problems, the duty of the representative to actually discover the will and preference of the person concerned is not sufficiently strong according to the wording of the law. And we see it here, that you have in practice a lot of times, as we are reported, shortcomings here that the actual will and preference of the given person is not truly actively tried to find out.
I will object to that point in that in this particular case, you can see that the person representing James Brown, the mother, has been reviewed in multiple courts, and they have upheld the legitimacy and the lack of a conflict of interest that she has in representing her son. I would point to a lot of credit in that, in being that she has chosen the tenancy for her son to live in due to the fact that there's a communication system, and she has expressed in her brief a will for her son to learn how to communicate so that he can eventually very clearly communicate exactly the situation that he would like to live. So I would suggest that in this case, she is acting very clearly on the basis of that person's will and preference and developing that ability to communicate that.
Okay, listen, can we?
It's beyond our knowledge to assess.
Yeah, okay, and don't forget, we have 1 minute summaries, so hold your points if possible.
And the final remarks goes to section 2 of the Westeros Act. The government has pointed out that there's plenty of sport alternatives available for its citizens. However, section 2, although it's prima facie, looks fine and provides a lot of options. The whole law, when you see the Westeros Act as a whole, suggests that support normally shall be given by way of representative agreements. And as the government representative himself pointed out that the decision or the choice of the complainant was to choose or to decide to enter a representation agreement. That very remark shows that the whole law indicates that the main means of support shall be by way of entering a representation agreement. And that, as an effect, rather facilitates substituted decision-making, other than overcoming that and moving towards supported decision-making. And reference at this point is made to the concluding observations of the committee on the initial report of Hungary of last year.
I would like to object and point out that representation agreements are available, but are not forced on anyone.
And I would further point out on the fact that you said that representation agreements are the only supports. You'll see in section 2.1 that local authorities shall mobilize the community and create social networks, including but not limited to representation agreements, and also that local authorities are shall observe binding guidance offered by the Office of Support and Independent Living. So representation agreements are, in fact, according to the law, only one aspect of support.
Yeah, and finally, we would like to point to some possible solutions. Our NGO, as you know, is the National Center for Civil and Human Rights and for Peer Support. And we have different professions hired, like lawyers and psychologists. And it could be taken further steps regarding to Article 12 to discover Jim's will and preference regarding his very important choice in his life. Because the very core of his disability is the ability to make decisions. It's more like asking a wheelchair user to go up the stairs. So it's not fair for him. For instance, assigning an independent advocate, which has to be a skilled communicator, and ombuds that's knowing him over time, a period of time, and gaining his trust, offering peer support of some sort,
Objection.
and teaching him self-advocacy skills.
I'm sorry. I would object to the qualification that the problem here is the ability of Mr. Brown's decision-making. The problem is Mr. Brown's communication skills.
It said in
I'm going to overrule on this occasion. I think it's all centers about supporting decision making. Okay.
Okay. Regarding Article 19 on solutions, one solution could be to offer him his own apartment in an ordinary neighborhood which he is familiar with, or living with flatmates of his own choose, not of others' choose, or living with his parents, his father maybe, or another with a personal assistant that he's chosen himself. So because then he can gain gradually more independence, and he can gain privacy, and it's also been proven that personal assistance introduce the need for force and restrictions, because we are very concerned about that. And in our organization we have the experience and we have learned the skill how personal assistants reduce the need for force. That's a very important point. And all this could do that he would gain community participation. And that's our last point. Thank you very much.
Thank you. Okay, I'm just in terms of just final 1 minute from the complainants and then from the government. And then we shall take some time out to reach our decision, and we will be coming back and giving you our decision, and as well as that we will be appointing an Attorney General for the Westeros government for the next 3 years. And so I think that's our challenge. So please, now I'm not going to accept any objections through this, right? Or if so, you're going to have to get past us first before you simply object. Okay? Keeping it in simple terms. So finally, by the way, is Janis Joplin in the room?
I believe, unfortunately, she passed away.
Okay, thank you. Right, final minute.
Your Honors, we'll just keep it simple and short.
Thank you.
Article 19 is about choice, individualized support, and access to service available to others. To live independently and be included at the same time in the community requires implementation of the 3 basic components of Article 19. But you have to keep in mind, living in a community does not mean living in a highly individualized sort of life, disconnected from the rest of society. So we simply ask, was it the case for James Brown? Did he make a choice at the beginning? Did he give all the support to decide on where to live, with whom to live, before resorting to the substituted decision-making, as we pointed out, in the form of representative agreement? A second question, did he get the support also? He needed to be, or to facilitate his inclusion in a community and his participation in other activities beside the one he did with the few people live with him who are like him. Inclusion and participation is not only about accommodation. It has also the other aspect, other rights included in the CRPD, including education, employment, having some responsibility of action within the accommodation and outside it. We believe in the case of James Brown, that was not at all there. Based on our communication and some of the government communication, it comes out that what happened to James Brown, that has been taken under the legal capacity and independent living regime of the government from the community to place him in a living accommodation which resembles to a great extent a small institution. And as we all know, a small institution is no different from a large institution. So what we ask your honors is just to reverse the situation in the light of the CRPD and the paradigm shift it tried to create, taking people to community, not to institutionalization.
Thank
again. And we thought you would do that.
Sorry? Now, I'm going to give a little latitude as well. I think that got about 85 seconds.
I will start. And in this side of my responsibility, I'll give a conclusion on behalf of my team as follows. Our position is very straight. We want to only submit that our involvement and conduct as government of Westeros in this matter has not in any way violated the provisions and intendments of Articles 12 and 19 respectively, with regards to the United Nations Convention on the Rights of Persons with Disability. Rather, it has further assisted in a great way in giving credence and effect to it by playing our constitutional role as a locus parentis to citizenry, as James Brown is in this case. We equally submit your lordship that the copious argument preferred so far by the councils to vote the complainant, Mr. Johnny Cash, and of the observation from the side of Banshall, My Voice, NGO, respectively, has not in any way, I repeat, has not in any way fully discharged the onus of establishing beyond the preponderance of probability a substantial cause of action necessary to substantiate the argument in this case. Or at best, it is said to have displayed a misunderstanding of the laws under discourse. Consequently, my Lord, we hereby humbly pray that this honorable court deems in fate to found in our favor. Thank you.
Thank you. Before we move off, is there anybody who would like to input to the committee's final decision? Thank you.